So now we come to arrest of persons. In the previous lectures, I've basically laid the groundwork for the rest of the course, right? I told you about the different functionaries under this code, right? The police, the prosecutor, the defense counsel, and of course the most important functionary, the court itself. Each of these functionaries will play a role in almost every aspect of the code, okay? But the most important functionary when it comes to the arrest of persons is, you guessed it, the police, okay? So let's get into it. What is arrest? Okay, arrest means the apprehension of a person by a legal authority resulting in the deprivation of his liberty. Very, very straightforward. Okay, I'm going to continue reading the slide. Arrest is the most effective method of ensuring an accused's presence at trial. Okay, now let's pause here. Okay, is it the most effective method? Yes, it is. Is it the most desirable method? No, right? Why? Right? Why is it not desirable? We'll come to that shortly. Okay? So it is neither desirable nor appropriate, the courts in India have repeatedly held, to use arrest in each and every case. Okay? Now, there are two types of arrest. Basically, that's arrest with warrant and arrest without warrant. Okay, those of you who have not even come across the CrPC before, know nothing about it. Even your parents, your friends, lay people who have nothing to do with the law will know that there are two types of arrest. You can arrest somebody with a warrant and you can arrest somebody without a warrant. In this lecture, we will be dealing with arrest with a warrant. Okay, now let's move on. Okay, and now we come to a very, very important section. One of those, how would I put it, one of those very, very, very crucial sections in the CrPC, and almost every law school and any judicial services exam that you're sitting for in Delhi or Maharashtra or UP or wherever will test you on this section, and that is section 41. Okay, section 41, the marginal note, deals with when police may arrest without a warrant. Okay, now let's not delay this any further. Let's start unpacking that section and see what it has to say. And I quote, any police officer may, without an order from a magistrate and without a warrant, arrest any person. Now let me pause over there. It says any police officer. Remember, okay, I told you earlier that the powers of police officers generally set out in the Police Act, okay, and also several of their powers in the CrPC. Okay, so any class of police officer who's essentially allowed to arrest a person comes within the ambit of any police officer under section 41. Don't bother yourself too much with all of those semantics, okay? So any police officer may, without an order from a magistrate and without a warrant, arrest any person. What that tells you immediately is that you need a order from a magistrate, right, generally to arrest a person, but under section 41, there are certain circumstances in which an order, which is essentially a warrant, is not necessary. What are those circumstances? Circumstance A, who commits in the presence of a police officer a cognizable offense. Section 41(1), right, subclause A is the easiest to explain for me in the CrPC. You're walking down the street, okay, and suddenly, right, somebody starts attacking you with a knife, okay, they're about to stab you, okay. By your luck, an assistant, let us say an assistant sub-inspector, an ASI, is also happened to be there on that street. He's walking down the street and he suddenly sees this individual attacking you. That police officer under section 41 clause 1 subclause A has the power to arrest that person who's attacking you. Why? Because he is committing a cognizable offense in his presence. What is that offense? If he's attacking you with a knife, the most serious cognizable offense would even be attempt to murder, which is very much a cognizable offense, a very serious offense. We've already done classification of offenses previously, so you know what I'm talking about. So, like I said, let's go back to the slide. Section 41 clause 1A, whoever commits in the presence of a police officer a cognizable offense may be arrested by a police officer without a warrant. Now let's move on to B, against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years. Okay, now the waters get a little more muddied here. What is section 41 clause 1 subclause B saying? Basically that the police can arrest without a warrant any person against whom, note these words, so important for you to know these words without referring to the bare act, a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years. So what are the various qualifiers here? First of all, Okay, under section 41, clause 1, subclause P, if the offense is punishable with a prison sentence of up to a maximum of 7 years, basically, what are the grounds on which a police can arrest without a warrant? There has to be a reasonable complaint made. Okay, let's go back to my analogy. You're walking down the street. Yeah, you're walking down the street. You're attacked by a person. Okay, what do? Oh my God, that person stabs you. Okay, you start to bleed profusely. Okay, you get to the nearest police station. Okay, basically you're still bleeding. All right, they attend to you. They call an ambulance. Okay, you're treated. Then the police come to you in the hospital and say, okay, tell us what has happened, basically, and the police take your statement. Okay, and how they take your statement, under what section of the CrPC, all of that we'll be dealing with when we come to the provisions on investigation. For now, let's say they just take your statement. In your statement to the police, you basically state that so and so person stabbed you, attacked you, basically, when you're walking down the street. On the basis of this complaint, the police register an FIR. Okay, so what is FIR? Which section of the CrPC do you have an FIR? All of that we will also deal with shortly. Okay, so police register an FIR. Okay, now the police have to make up their mind whether the complaint that you have made is a reasonable one. Okay, so it's up to the police officer. It is the subjective satisfaction of the police officer, right? And the court will have to apply objective standards to the decision, okay, that the police officer took. They will have to see whether the reasonable police officer in that particular case was justified in coming to the conclusion that the complaint you made was a reasonable one. On the basis of this complaint, you have given a good description of this person, and the police say, oh, we know this person, he has stabbed several people in the area, we have we've arrested him previously for various offenses, he is currently out on bail, we will go find him. So and the police say, oh, I know this person, his name is Raju or Ramu or whatever. Oh, Raju, it's Raju's the one who has stabbed you, he has done this before to other people, we are going to go arrest him. They go and arrest Raju without a warrant. Okay, just remember this little example for now. Okay, now the other ground on which they can arrest basically is credible information has been received. Okay, so credible information has been received. They say, yeah, this information we have received from this person is credible, we can arrest that person without a warrant. And the police also believe you, and they say, okay, you know what, we have a reasonable suspicion now that Raju has committed the offense, and they go and arrest him without a warrant. Okay, now earlier I alluded to the fact that when somebody tries to stab you, the most serious offense is attempt to murder. Okay, now there should have been an alarm bell going off in your head when I gave you this example of Raju stabbing you. If the offense is one of attempt to murder, ladies and gentlemen, the maximum sentence for attempt to murder is in excess of 7 years. So you must immediately say, well, Professor Sudhir, how come you're saying attempt to murder? Section 41 clause 1b only deals with offenses which are punishable with a maximum of 7 years. Very good. If that's your thinking, you're very, very right. If it's attempt to murder, it will not be covered under section 41 clause 1 subclause B. Okay, let's assume it is a different sort of offense. It's an offense of, let us say he has not stabbed you, but he has basically taken the knife and he has grazed. Okay, he has basically, let us say, grazed your arm or something like that. Okay, the police say, I don't think he's tried to murder you, he's grazed your arm. And the police say, it's probably, it could be voluntarily causing hurt. Maybe it's voluntarily causing hurt by dangerous weapons or means. The police say, we're not so sure, we want to charge him with such a serious offense. There's very minimal hurt, there's barely a scratch on you, basically. And the police say, this is not a case of grievous hurt, this is a case of simple hurt, basically. So you see the exercise the police will have to perform. This is why they need to know the CrPC very well. They'll say, actually we feel that the offense here committed is a case of causing simple hurt, basically. Okay, causing simple hurt is under 7 years, they will say. Causing simple hurt with dangerous weapons means, okay, now look at the first schedule, see the sentencing. Police will say, if it's under 7 years, if it's under 7 years, I need to make sure that the complaint is reasonable, that the information I've received is credible, that the reasonable suspicion exists that Raju has committed this offense. Okay, remember, all of these tests are disjunctive. Okay, they are disjunctive tests. What do I mean by that? Not all three conditions have to be satisfied when the offense committed is under 7 years. One condition is sufficient. So if they say complaint is reasonable, enough. If they say credible information that cognizable offense has been committed, enough. If they say, no, I as a police officer now have reasonable suspicion that Raju has committed this offense, which is of under 7 years, enough. Go and arrest him without a warrant. Okay. So basically very, very simple. Okay, when you go arrest without a warrant, now let's move on to that, right? Arresting without a warrant is dealt with in section 41(1) clause BA. Okay, so what happens in section 41(1) clause BA, right? The police essentially under that clause, right, are given the power to arrest without a warrant when the offense punishable is in excess of 7 years, but that clause is slightly different from section 41 clause 1 B basically. So what does clause 1BA state? And I quote, basically a person may be arrested without a warrant by a police officer who has reason to believe on the basis of credible information received against the person that he has committed a cognizable offense punishable with imprisonment exceeding 7 years or with death. Okay, so what is section 41(1)BA stating? Basically, look, the threshold for the police officer has to meet is very, very low. Okay, as long as he knows that, okay, police say, okay, they get a complaint from you in the hospital, right? There's no question of the complaint being reasonable. Okay, there's no question of there being some sort of reasonable suspicion. Okay, all the police have to satisfy themselves is that the information you're giving to them from your hospital bed is credible information, and of course then the police will come to a determination that, you know what, no, actually what Raju has done to you, he's taken a knife, he has stabbed you near the heart, you luckily survived, luckily you came to the police station, we were able to get you treatment. So in a situation like that, the police will say, no, this is a clear case of attempt to murder, it's punishable in excess of 7 years. I believe the information, the police officer, the SHO, the station house officer, the officer in charge of that police station where you have gone and collapsed basically when you're bleeding because Raju has stabbed you, that police officer has come to a determination that the information is credible. Under section 41(1)BA, the fact that the information received is credible is enough. He will go and arrest Raju on suspicion of committing attempt to murder, of trying to murder you basically. Okay, so I hope you understand the different aspects, the different limbs of sections 41(1)A, B and BA. These are the three most important limbs of sections 41(1)A, B and BA. Okay, so quickly I want to go to another slide. I just want to deal with what is the meaning of all of this. What is credible information? What is reasonable suspicion? Let's go to the slide. Well, the courts have repeatedly held it depends on the facts of each case. So ladies and gents, come on, this is straightforward. The illustration I've given you, right, is it depends on the facts of each case. See how I went into whether whether he stabbed him, whether he grazed his hand, the stabbing was near the heart, things like that. What time of day did the incident take place? Basically, is the complainant believable? Again, that's something the police have to come to a determination on. Okay, so the police, basically, there must be an honest belief in the mind of the police officer receiving such information that a cognizable offense has been committed. Okay, now the existence of the warrant is equivalent to credible information, and it does not matter that the warrant was not addressed to the officer in question. Okay, very important. Okay, now pay close attention to what I'm trying to say. You see here how the CrPC is so how do I put it, intricate basically. Let us say a warrant has been arrested to this police officer called Shahrukh. Okay, the warrant says Shahrukh has the power to apprehend Raju, but in fact Amir, his colleague at that same very police station, although he's a subordinate officer, is aware that there is this warrant that has been issued for the arrest of Raju. Okay, in the previous illustration, basically I said they can arrest Raju without a warrant. Okay, but you know what? Shahrukh, the police officer, says, no, you know what? It's okay. There is time. Let me go and get a warrant from the magistrate. Okay, we'll come to the grounds on which, the police can approach the courts for a warrant, etc. later. Okay, for now, just know that a warrant exists basically for the arrest of Raju. The existence of the warrant is equivalent to credible information, and it does not matter that the warrant was not addressed to the officer in question. So, Shahrukh's subordinate Amir in that police station, let us say Shahrukh is the sub-inspector, let us say Shahrukh is the SHO, let us say Amir is the assistant sub-inspector. Assistant sub-inspector Amir suddenly sees Raju walking down the street and says, oh, he calls Shahrukh, his superior, and says, boss, देख लिया मैंने राजू को, अरेस्ट करूँ, वो अरेस्ट करूँ. शाहरुख says चलो चलो अरेस्ट करो भाई, कोई बात नहीं है. बट आमिर says सर तो वारंट आपके नाम में है ना सर, वारंट मेरे पास नहीं है ना सर. Shahrukh says don't worry Amir, under section 41 basically existence of warrant is credible information, and it does not matter that the warrant was not addressed to you Amir, you can go and arrest Raju. And finally, let's go back to the slide. Mere registration of the FIR may not be sufficient to give rise to a reasonable suspicion. So it is not simply enough basically for the police to say, I took a complaint down from this the alleged victim in the hospital. On the basis of that complaint, we registered an FIR. Because FIR was registered, that is sufficient to give rise to a reasonable suspicion. Remember again, ladies and gents, reasonable suspicion only matters when the offense is under 7 years. The offense punishable is up to or under 7 years, basically. Okay, when it is in excess of 7 years, it is simply put credible information. Okay, now look at me and pay close attention as I just sum up the law under section 41, clauses 1A, B and BA. Okay, very simple. Clause 1, you can arrest a perpetrator, the alleged perpetrator, basically if the offense is committed in your presence as the police officer. You, the police officer, can arrest without a warrant if credible information has been received. You, the police officer, can arrest without a warrant if there is a reasonable suspicion in your mind, you have an honest belief that a cognizable offense has been committed. You, the police officer, can also arrest, basically, right, if the grounds exist, right, under section 41, 1B, okay, basically that a reasonable complaint has been made. Okay, so these are the three grounds, and all of this is when the offense is under 7 years. I hope you've got that. The offense is punishable with under 7 years, but offenses like murder, attempt to murder, rape, etc., punishable in excess of 7 years. Like I said, all the police needs under section 41 clause 1BA is that, right, there is credible information against the person that you wish to arrest that he has committed a cognizable offense punishable with imprisonment exceeding 7 years or even with death. Okay, and basically what is credible information, what is reasonable suspicion, I've already explained that to you. Before departing from this area of the law, I quickly want to quote from Kajal De versus State of Assam. I've given you a nice little lengthy extract which you can now see on your screen. Okay, pause this video and read it carefully. I'm just going to give you that highlighted part which basically the court said, the Guwahati High Court said that the suspicion must be well founded, and they said all efforts must be made to apprehend the culprits involved in the crime. But that does not entitle the police to exercise the power under section 41 CrPC arbitrarily and to trample the dignity and liberty of the citizens, basically, okay, the safeguard of which is guaranteed under our constitution, basically. And therefore the court said mere suspicion must not arrest a person. Okay, now you're going to say, sir, what is this, sir? You just told me reasonable suspicion is enough, now you're saying mere suspicion is not enough. Yes, you see the difference. Reasonable suspicion can never be mere suspicion. Rather, the other way, mere suspicion can never be a reasonable suspicion. Okay, it has to be solid. There has to be solid grounds. There has to be strong grounds of the police to come to the conclusion that you know what, this information is credible, and this this leads me to a reasonable suspicion that Raju has committed the offense. Remember, when a few minutes ago I said, the police is taking another statement, and he says, oh, we know, oh no, this modus operandi, this MO, this style in which you have been stabbed is very, very remnant of what Raju does. Raju is a serial offender. He keeps stabbing people. That gives you not just a mere suspicion, but a reasonable suspicion. Okay, basically. Now, if you say, oh, you know what, this Raju, he looks like a bit of a dodgy character. This Raju, yaar, wo thoda character deela hai uska, arrest karte hai. No, that is simply mere suspicion. You cannot arrest somebody on willy-nilly on the basis of mere suspicion, on mere hunches. Okay, the police can't say, I had a hunch. Sir, मुझे लगता था कि राजू ने किया है, इसीलिए मैंने बिना वारंट उसको मैंने अरेस्ट किया है. Basically, okay? The courts will strike that down and will rule that arrest is unlawful. That is an unlawful arrest. Okay, so before we move any further, I just want to wrap up on the remaining subclauses of section 41. Right, they lay down, say, various other grounds on which arrest can be effectuated without a warrant. Let's go to the slide. So under section 41 clause C, basically the police can arrest a proclaimed offender under this code. What is a proclaimed offender? Just hold on to your horses. We're going to be dealing with that when we do section 82 and section 83 in the next lecture. Okay, proclamation, etc. Just hold on for now, but know that a proclaimed offender may be arrested without a warrant by the police. The police under D may also arrest any person who is found in possession of stolen property and who may reasonably be suspected of having committed an offense with reference to such thing. Very, very simple. All of you have seen the Akshay Kumar movie Special 26, right? Basically were on the grounds, they basically defrauded people. They said they were CBI officers who were conducting a raid and they stole jewelry, etc., etc. Police, or let's say it's a bank robbery, a bank heist, the police get a call basically and say, sir, Indian Overseas Bank or Axis Bank, the robbery, there has been a there's been a robbery. People have used 5 or 6 individuals came into the bank with guns. Basically, they held everybody at gunpoint. They took the money. Police get the call. Then they suddenly go to the spot, and then they see there's something suspicious, that there is this fellow who is acting in a very suspicious manner, and they see that he has a bag, and they stop him, and they see that he has a bag full of fresh, crisp banknotes. Basically, they can arrest him under Section 41, Clause 1D. Okay, basically. Also, the police can also obstruct a police officer while he's in the execution of his duty. So, for example, let us say, we're seeing these protests over the release of the movie Padmavati right now. Basically, let us say the police have been called to a particular theater. Various individuals are vandalizing that theater. The police try to arrest the chief, the lead of that mob, the head of that mob, the guy who's orchestrating the violence. And when the police tries to arrest him, his superior basically punches him, gets in his way. What is he doing? He was obstructing a police officer in the execution of duty. That person can also be arrested on the spot without a warrant. Okay, going on, Section 41, Clause 1, where are we now? F. Basically, right, the police can arrest somebody who is reasonably suspected of being a deserter from any of the armed forces of the Union. Basically, so we don't really deal much with offenses committed under the jurisdiction of the Army Act, basically, but the police have a right to arrest without a warrant any deserter. Okay, so let us say there is a war going on, let us say Pakistan attacks India, there's a war going on, then there is this gentleman who says, I've had enough of this war, and he deserts from the army without permission. That is a criminal offense. In addition, he will of course be tried, he will be court-martialed, he will be tried by the army tribunal, but his arrest can be effectuated by the police. So, in a place like Pune, for example, very large cantonment, you have the police can arrest that any person who is suspected of being a deserter from the armed forces of the Union. So, basically, he has deserted the army without permission from his superiors. Okay, basically, let's move on. Let's go on to the next slide. Section 41G, basically, the police can also arrest any person under Section 41G, basically, who has committed an offense on foreign soil. Okay, so he has been concerned in or against whom a reasonable complaint has been made, or credible information has been received, or reasonable suspicion exists of him having been concerned in any act committed in any place out of India, which if committed in India would have been punishable as an offense, and for which he is under any law relating to extradition or otherwise liable to be apprehended or detained in custody in India. Okay, so the example I want to give you here is the case of Mahendra Pal Singh Kohli. I think that was his full name. He was a Sikh man as in he was a Sardarji, basically, who raped this British girl by the name of Hannah Foster. He raped Hannah Foster in approximately 2003, I think it was, in the city of Southampton in the United Kingdom. Kohli raped Hannah Foster, and then he fled to India before he could be apprehended by the British police, the UK police. Basically, various procedures, various negotiations took place between the sovereign governments, between the Prime Minister of the UK, the government of the UK, and the government of India. Basically, and Kohli was extradited. Okay, so Kohli was arrested and he was extradited back to the UK to face trial, and he's currently lodged in a prison in England. So basically, a person like Kohli, somebody who has committed an offense on foreign soil and is now in India, people like Charles Sobraj can all be arrested without a warrant under Section 41 G, basically Section 41 Clause 1 subclause G. Think about it logically, right? Could you actually go for a warrant, right? You're seeing this perpetrator, this guy, a guy like Charles Sobraj, who could escape at any given time. Basically, you would like to arrest him. Assume Charles Sobraj has committed offenses in multiple countries, okay? So there's no time for you to go to a magistrate and get a warrant, okay? So slowly those wheels in your mind should be turning now, because I'm sort of getting to that stage where I'm telling you why you would need to arrest without a warrant. Okay, quickly guys, wrapping up, Section 41 Clause 1H says that anybody who is a released convict and breaches rules made under subsection 5 of Section 356, these rules relate to residence requirements of released convicts, basically can also be arrested. You see this all the time in American movies. They call it parole violations. Basically, even recently, a very famous rapper in America by the name of Meek Mill, I don't know if you guys listen to hip hop, I certainly do. He has been sent to prison for various what they call probation violations. We have Probation of Offenders Act, etc. Don't confuse all of that with this. Very simple. Let us say you have been released. You have told the police that you're going to stay at this address in Lokhandwala or wherever. Basically, you don't stay at that address. That's a breach of your residence requirements, basically, and you can be arrested without a warrant when you have breached those residence requirements. Very, very simple. Section 41 Clause 1I simply states that a requisition, whether written or oral, has been received from another police officer, then you can arrest that person without a warrant, provided that the requisition specifies the person to be arrested and the offense or other cause for which the arrest is to be made, and it appears therefrom that the person might lawfully be arrested without a warrant by the officer who issued the requisition. So basically, right, like I said, Shah Rukh has credible information, let us say, that Hrithik has committed the offense of murder. It comes to Shah Rukh's notice that Hrithik is now in the state of Karnataka. Shah Rukh writes to the let's say Hrithik is in the district of Belgaum, which borders Maharashtra, and let us say Shah Rukh is in the district of Kolhapur, which borders Karnataka, basically. Okay, Kolhapur in Maharashtra, Belgaum in Karnataka. Basically, these two officers write to each other. Let us say Shah Rukh writes to Salman, Salman, please arrest Hrithik. He has committed murder. I have credible information, received credible information that Hrithik has committed murder. I don't have time to get a warrant immediately, so please, if you can apprehend him, I would be grateful. Salman receives that written requisition. Clearly, Salman says that yes, that the requisition specifies the person to be arrested is Hrithik. The requisition specifies that the offense that Hrithik has committed is one of murder, and the requisition, it appears from that the person might be lawfully arrested without a warrant by Shah Rukh. So Shah Rukh would have to go a little further, basically, and tell Salman why exactly he believes Hrithik committed murder. What is the credible information that he has that Hrithik has committed murder? Guys, this happens a lot in cases of hot pursuit, and I'm going to deal with the case of Hanipreet Singh very shortly. Hanipreet Insan, the daughter, quote unquote, of Gurmeet Ram Rahim, who is currently lodged in Rohtak jail as a convict for committing the offense of rape, basically. So when I deal with Hanipreet Singh, this issue of arresting people outside jurisdiction, outside the local jurisdiction, will become apparent. Okay, but in your mind, I hope you can sort of start to appreciate the federal nature of India's criminal justice system. India is truly federal when it comes to the CrPC. Basically, we talk of jurisdictions within India, we talk of jurisdictions, the district of Kolhapur and the district of Belgaum, we talk of districts within a state, right? Even Kolhapur and let us say Satara, different districts, for example, then each police officer will have to make a requisition to the other police officer in that district. Okay, and when he does not have a warrant, the procedure is governed under Section 41 Clause 1I, and when there is a warrant, well, that procedure is governed, as we will see in the next lecture, right, under Section 78. Okay, warrant of execution of warrant outside the jurisdiction of the local jurisdiction of the officer. Okay. Let's quickly wrap up on arrest. Let's move on now to Section 44, which deals with arrest by a magistrate. And let's go to a slide. Under Section 44, Clause 1, a magistrate himself has been given the power to arrest a person who has committed an offense in his or her presence and commits that person to custody and can commit that person to custody. Under Section 44, Clause 2, the magistrate can arrest a person suspected of committing an offense but cannot commit that person to custody. Person should be produced before another magistrate for obtaining an order of remand to custody. Okay, guys, I've put up an image with this slide. That is the demolition of Babri Masjid. Do not worry about remand to custody. Do not worry about all of that for this moment. We will deal with remand when we do police and judicial custody. The big takeaway from Section 44 for you is a magistrate may arrest a person who commits an offense in his presence. Okay, right? It's as simple as that. Okay, basically, he sees a person committing an offense, he may arrest him under 44.1. Under 44.2, magistrate can arrest a person suspected of committing an offense. Okay, why have I put the Babri Masjid there? In the demolition case here, the Kar Sevaks, basically you are looking at these people committing an act of vandalism, you're looking at these people demolishing a mosque. Basically, that is a criminal offense. What they were doing was a criminal offense. I mean, take your pick. The amount of damage, we're talking about criminal damage here. We're talking about breach of the peace. We're talking about a violation of the section 144 curfew, the section 144 prohibitory orders. We're talking of an unlawful assembly. We're talking of rioting. I mean, my goodness, the number of offenses the Karsevaks committed was, well, a litany of offenses, let's put it that way. So the magistrate is viewing this. He sees that they are an unlawful assembly. He sees they're committing violence. Magistrate, okay, this happened in Ayodhya, right? The DM of Faizabad, I think at the time was Srivastava, a man by the name of Srivastava, if I'm not mistaken. Arrest. He's walking down the street there in Ayodhya. He's near the Babri Masjid. Arrest karo. Yes, police with him. Arrest karo. Magistrate has the power to do that under section 44 without a warrant. Think about it logically, guys. The mosque is going to come down. Where do you have the time? Where do you have the time to go to a magistrate and get a warrant, right? Where do you have the time to go to a court and get a warrant? Basically, okay, so magistrates are given the power, both executive and the judicial magistrates are given the power under section 44 to make an arrest. But remember that corollary I said in terms of remand to custody, right? Going back to the whole thing of investigation, prosecution, judiciary, executive being separated from each other. You cannot have an arresting magistrate also deciding whether that person should be granted bail or not, or whether that person should be remanded to police or judicial custody. We'll deal with this in greater detail, but just know, big takeaway, section 44, magistrates can also arrest. Quickly, guys, moving on to section 46. What does it mean to make an arrest? Okay, so what is an arrest? What does an arrest consist of? So an arrest consists of taking a person into custody under authority empowered by law for the purpose of holding or detaining him to answer a criminal charge and or preventing the commission of a criminal offense. Very simple, guys. This is a definition. You will have a 2-mark question sometimes, especially if you're at a state university. They will say define arrest. Here is your definition of arrest. Arrest is the actual seizure or touching of a person's body with a view to arresting that person, basically. So there has to be a seizure or a touch of that person. Basically, that does not mean you have to slap the handcuffs on them. That does not mean you have to wrestle them to the ground. You do not have to be violent. Basically, it is sufficient even if the movement of a detainee is restricted within the premises of the police station. Even in a scenario like that, it is an arrest. You will see the image of Tarun Tejpal, against whom charges have now finally been framed after almost 4 years in a case of rape against one of his employees. You know, the image of Tejpal there. Why? Because Tejpal was questioned for hours on end in a police station in Goa, and finally they said, they restricted his movement and said, you're under arrest. They simply touched his body and they said, you're arrested. And you will see this on the news as well. There are many, especially the high profile cases where you have people like Tarun Tejpal, Indrani Peter Mukherjee, people like this. You don't see them with handcuffs on because they're cooperating with the police. So police they will simply touch the body of the person and say you are now under arrest. If they detain them within a police station, say you cannot leave this police station, now you are under arrest, basically. Okay, why is that very important? The moment you're placed under arrest, you are entitled to various rights as an arrested person. So you cannot give the police sort of carte blanche. You cannot give them a loophole that they can exploit, wherein they will say, oh, you know what, we never actually handcuffed the person. He was not arrested. He was free to leave, even though you have kept him in the police station for 3 days, basically. So you've kept him there for 3 days. It's as good as arrested him, because you have said, if he's asked you, it's been 3 days, can I leave? You say, no, you can't leave. That means, if he asked you that on the first day, no, you can't leave, it means you have arrested him, basically. The police in this country, ladies and gentlemen, boys and girls, students, they cannot restrict your movement, basically, right, in a police station and say you have not been arrested. You're either free to leave, or if you're not, you're under arrest. It's as simple as that. Okay, so do not cooperate with the police, as any lawyer will tell you, if you do not want to cooperate with the police. It's as simple as that. Okay, so once you're arrested, the rights of arrested persons, etc., come in, which we will deal with in the next couple of lectures. Okay, I just also want to quickly look at section 49. Let's go to that slide. Section 49 basically states that there should be no unnecessary restraint. Basically, unnecessary restraint, this goes back to my point of wrestling them to the ground. It's not necessary. Okay, and the court, in the case of Citizens for Democracy was the state of Assam, 1989, the Supreme Court Apex Court has held that when the police arrest a person in execution of a warrant of arrest obtained from a magistrate, the persons who are arrested shall not be handcuffed unless the police has also obtained from the magistrates for the handcuffing of the person to be so arrested. I'd like to pause here, right? This also applies when you're arresting them without a warrant. Okay, so what is the Supreme Court? We have not come to warrant yet, and in what situations warrants are issued. But just know that when you apply for a warrant, you should also ask for permission to handcuff the a person to be apprehended, to be arrested, basically. Okay, so that's what the Supreme Court says. Also, that it applies to where a person is arrested by the police without a warrant. Okay, so when the person is arrested by the police without a warrant, the police officer concerned may, if he is satisfied on the basis of the guidelines given by the Supreme Court, it is necessary to handcuff such a person, right? The police may do so till the time he is taken to the police station, and thereafter his production before the magistrate. Further use of fetters thereafter can only be under the orders of the magistrate. So if you have a warrant, you should have asked at the time the warrant was granted that you wanted to handcuff this person. If you don't have a warrant, you arrest without a warrant under section 41 in all those instances. The moment you arrest them, you handcuff them, you bring them to the station, you produce them before the magistrate. When you produce them before the magistrate within 24 hours, you have to ask for permission from the magistrate for further fetters, for handcuffing them. Okay, in a case of like somebody like a Charles Sobraj was arrested, you will definitely apply, you will make an application to the magistrate to use handcuffs at all times, because this guy is notorious for escaping, basically. Okay, so that is what the Supreme Court said in the Citizens for Democracy case. Okay, guys, let's go to another slide. Arrest of female persons. You see the image of Kanimoli, the daughter of the DMK Supremo Karunanidhi there. Kanimoli, if you all remember, was arrested in the 2G case, which we will deal with also in the context of bail. Section 46, Clause 4 states, arresting authority must make all possible arrangements to ensure presence of woman constable when a female person is being arrested. If the presence of a female constable or a female police officer cannot be assured without causing prejudicial delay to the investigation, arrest may be effected by male officer for lawful reasons at any time of the night or day, and the reasons for doing so must be recorded. Now come on, ladies and gents, remember, okay, many people say this, okay, there was a funny little video that some of my former students made a couple of years ago, and they boldly declared that a woman can never be arrested by a male police officer. That is a ludicrous declaration to make. Think about it logically. Basically, a woman is about to, let us say, stab another woman, right? You're a male police officer and you're seeing that she's about to stab another woman. She's being aggressive. She has a knife in her hand. What is she doing? Section 41, Clause 1A. What is she doing? She's committing a cognizable offense in your presence. Okay, basically she has a dangerous weapon. She's looking to cause hurt with that dangerous weapon. Cognizable offense. Are you telling me in a scenario like that, you, a male police officer, cannot arrest that woman? Are you saying in a scenario like that, you cannot restrain that woman? Of course you can. Okay, so that is what Section 46, Clause 4 states. It states you must make all possible arrangements to ensure presence of woman constable, but if there is prejudicial delay, basically the arrest may be effected by a male officer for lawful reasons at any time of the night or day, basically. Okay, and generally, right, if there is no prejudicial delay, there is no offense being committed in your presence, there is no delay, there is no question of the woman tampering with evidence, let us say, there is no need for her to be arrested immediately, then the police should wait, right, ensure that a female constable at least is present, and they should effect the arrest preferably during daylight hours, but not at night. Okay, basically. But if they have a police officer, right, a female police officer, and the arrest has to be effected in the middle of the night, they can do it. Even if they don't have a female police officer, they can arrest a woman in the middle of the night, but they must have clear reasons. Their reasons for doing so must be recorded. Okay, guys, so basically I have laid out everything there is to do with arrest without a warrant. Okay, so there are a couple of ancillary provisions, just the last couple of slides. Let's go to section 41, search of a place entered by persons sought to be arrested. Basically, right, I've put the image of Operation Blue Star. You're looking at members of the armed forces and the Punjab police who are at the Golden Temple in Amritsar. Basically, what are they doing? Right, they are looking for Bhindranwale, right? Remember Bhindranwale, the terrorist, head of the Khalsa movement, basically, who was shot and gunned down in the Golden Temple. Many people consider it disgraceful that the police entered a holy place and engaged in a gun battle there. Under section 47, however, the police may search a place entered by a person sought to be arrested. This applies to cases where there is a warrant and where there isn't a warrant either, basically. Okay, under section 47, the police have the power to search that place, and that is what they did in the case of Bhindranwale and Operation Blue Star in 1983. Okay, now we finally wrap up this lecture with section 48, which is pursuit of offenders into other jurisdictions. Again, the police have the power to pursue offenders into other jurisdictions. Guys, I'm talking about local, like I said, even from Kolhapur to Satara to Belgaum to different districts in Hyderabad or wherever in Telangana or wherever the police have the power to pursue offenders that they're seeking to arrest without a warrant. They can do so basically under section 48. The good practice to be followed, like I said, is at least inform the police there, the local police, that you are coming, and they will assist you. So it basically depends on the personal equations between the police forces of the respective states and the respective jurisdictions. Okay, so let's just go to the slide. I've given you a nice illustration of how the Haryana police pursued Hanipreet Insan. Basically, they followed her to Rajasthan. She was she was spotted in a shopping mall in Udaipur. And they missed her there. Then they thought that she was going to Nepal, so they went to the Nepal border. They couldn't find her there. Basically, they took the assistance of all of the state police, UP, Bihar police, etc. Basically, the states that share a border with Nepal. She could not be found. Then suddenly, the Haryana police came to know that Hanipreet met her lawyer in Lajpat Nagar in Delhi. They went there. They missed her there as well, but finally on October 3rd, they were able to apprehend her. They arrested her near Chandigarh on the highway, basically. So the police pursued her into several jurisdictions, different districts in the state of Haryana, different districts in the state of Rajasthan, UP, Gurgaon, Lajpat Nagar, and Delhi, all over the place. Section 48 gave them the power to pursue offenders, pursue people who are sought to be arrested, like Hanipreet Insan, into other jurisdictions. That brings us to the end of this lecture on the arrest of persons.